Good morning, colleagues, and I recognize Professor Thomas. I recognize the gentleman we had a lovely dinner with last night, Mr. Duke Pollard, seated next to the Professor Duke Pollard, seated next to the lady with the afro, who asked interesting, penetrating questions. So I wanted to start off this morning by trying to get us a little bit of a snapshot in terms of sometimes you feel a bit disheartened and you tell yourself, well, all we do at these conferences is talk. And it's more talk. And what's the difference between this conference and the one from last month and the one from 2 months ago? So you can get a bit disheartened in this type of work. And it's a long struggle. And I want to say that one of the most interesting things about conferences is engagement and debate. Even for those of us who feel we know a lot or we know plenty, some of us feel we know everything. And yesterday I had a lovely engagement with our colleague Perry. Perry, are you there? There's Perry. Perry and I had an off-the-book thing by the stage. He asked me a question and I got angry and I answered him, and I want to share it with you all. Because one of the points in yesterday's presentation that I gave was about the perils of the cost-based model for approving contracts, for awarding contracts. And the focus of the conference, rightfully so, is on financial crime and the need for good public administration to carry the country forward. But I want to say that the danger of the cost-based model is far, far more than a mere financial threat. And I thank you, Perry, for bringing it to my attention, and I'm going to put it to the audience now as a starter for 10 points, is to talk about that Grenfell fire tragedy in London. What has that got to do with this? In fact, it's got everything to do with it. My professional background as a chartered surveyor, I practiced for years as a project manager in the housing associations in London, building large-scale low-income housing, exactly like that project. The contractor who did the project to put the cladding on the building is a contractor called Ryden, which I've worked with, and they're a good, competent firm of contractors. I don't associate Ryden with any stupidness in terms of construction work. So what happened? And we got to get back to the philosophic point about what are we doing and why are we doing it. In procurement, we call it a needs assessment. And for this discussion, we need to have a needs assessment. What are we doing and why are we doing it? In the case of Grenfell, it was revealed in the subsequent reports after the tragedy that in fact, the particular cladding that was selected, which is prone to burning rapidly, was selected on the basis of that's a new four-letter word, cost. It was selected on the basis of cost. And what you will find, because there are now calls for public inquiry, and who should be the chairman, and what are the terms of reference, and the loss of life, and the role of poor people within the housing stock, the state housing stock. These are important debates. Of course, they're being scattered by the party political thing with Corbyn and so, but we have to stare to the truth. The truth, I suspect, will be that when that examination takes place, the public inquiry, and is published, these things are published, unlike in our countries where things often aren't published. These things are published in the UK. What we will find is that the cost-based approach that I am critical of, the cost-based approach that is at the root of the Grenfell tragedy, the cost-based approach was probably the agreed approach. It was probably the approved approach. It was probably the accepted approach. This is why it's important to have your philosophy correct, to avoid that type of tragedy, and the tragedy can span beyond an injury to the treasury. So that's the importance of the Grenfell example, and that is the importance of us understanding the particular perils of the cost-based approach to project approval. Let's get to today's topic. That's the warm-up. What is the nature of the problem? The nature of the problem is really be trying to figure out ways to tackle this pernicious issue of corruption. And as I said here, corruption is the abuse of a position of trust or authority for the benefit of yourself, your friends, your family, or your financiers. Yesterday I quipped and I said there are 5 F's. Friends, family, and financiers find favor. 5 F's in this country and in Trinidad and Tobago and many parts of the world. You have to recognize it to fight against it. The problem is huge, and I've been asked to speak to to the three different models. And in fact, the title I chose was the Integrity Matrix, which is another sort of tongue-in-cheek thing, because the Matrix is that hugely popular movie about an alternative world. So you think you live in this world, but they have a whole other world out there that is controlling this world. And that is a real dialogue about the whole nature of corruption. The other world is controlling this world, the world we don't see and the world we hardly talk about. I'm going to talk about it now. I'm not going to give much time. I'll talk a little bit about the single agency question. So the single anti-corruption agency is practiced in these four countries that I chose to speak about. There's Hong Kong, Singapore, there's Sierra Leone, and there's Liberia. And there's some features I've picked out just for consideration. I'll run through them quickly, and I get to the meat of the thing about what the Caribbean question is, and the SARA and so on, because colleagues are here from SARA. We want to spend some time going into that. So in Hong Kong, it's interesting. Eric used a very fascinating quote yesterday, Eric Williams, not Dr. Eric Williams. Eric Williams is second. He used a fascinating quote yesterday, and he said, it was from a book he had read, I forget the title of the name of the author, but the quote was, "Culture eats strategy for lunch." And the most fascinating thing I found about the Hong Kong reading and the Hong Kong Independent, Commission Against Corruption, was that in fact, in their 2016 annual report, 71%, this is so amazing, 71% of the reports of corruption, people give their name and their details, because reporting corruption is something that's considered to be highly acceptable. The level of threats is very low. 71% of the cases, people gave all their details. That's a very interesting benchmark. Also, there's the fact that they have taken on a very creative approach to the educational question I mentioned yesterday, because the biggest part of this is to educate the public to be aware of what is corruption and what are its dangers, how is it fought, how is it detected, what can you do as a citizen. And they've actually launched their own reality TV series in April of 2016, about cases that they have done and so on. And whenever they show it, they have 2 million people watching it to inform the public about the work of the ICAC. They have a three-pronged approach. They have law enforcement, they have prevention, and of course they have community education to fight corruption. And Hong Kong has done very well. I think they're 15th out of 176 countries in Transparency's 2016 report, and they have a score of 77. Hong Kong has done very, very well. Singapore, which is the next agency, has a Corrupt Practices Investigation Bureau. And what is the fascinating point about that one? A little bit like Hong Kong, but this one is stronger. Singapore actually investigates and prosecutes public and private prosecution. Corruption. So they're not focusing only on the public element of corruption. So if you run an airline, and a private airline, and you have a corrupt arrangement with her, who's a caterer, a member of your staff could report you for that corrupt arrangement, and the two of you could face the courts under the Singapore arrangement. Okay? They're that serious about it, and they mean to stop that behavior in the society. So effectively, they have actually come out 7th out of 176 countries in the 2016 Corruption Perception Index. And they have a score of 84 out of 100. So in fact, it's a very impressive way of approaching the question. I mentioned the Hong Kong agency prior, and the Hong Kong agency does some education as far as the ethics of the private sector is concerned, but I'm not aware that they actually prosecute the private sector in the way the Singaporeans do. Sierra Leone. The head of the Sierra Leone Anti-Corruption Commission is a fella I met, a lovely guy, one of the epic people I met in my life. In March of 2014, I met him at the University College of the Cayman Islands. We had a conference there on making a corruption-free Caribbean, which is hosted in the Cayman Islands. So Joseph Kamara is his name, and he came out of that war situation in Sierra Leone. And their website actually declares a number of extremely ambitious objectives, and they've done some serious prosecutions. The mayor of Freetown, members of cabinet have been prosecuted and convicted and so on. But yet, the organization has not gotten to its full potential. So they have, almost at the bottom of the CPI, there are 123 out of 126. And the score of the country is only 30. And then, of course, is Liberia, which has an organization with the same title as the prior one, and also with an ambitious program of work to do with education and prosecution and investigation. And their score is around the same place. I don't know if to be happy or to be sad, but their score is around the same place as Trinidad and Tobago and Guyana. So they are number 90 out of 176, and their score is 37. So I think our countries are around the same, settle around the same average. And one of the questions we need to talk about is how do we actually modulate power in these situations? And it's a situation we had to deal with in Trinidad and Tobago when we were trying to create the law for the Public Procurement Office. Because you have a serious social problem and you want to create a new institution to deal thoroughly with it. You want to vest the institution with the powers, lawful powers, to do its work, to investigate, to call for papers and analyze and arrest and so on and so on. At the same time, you need to cloak the agency to a certain extent in immunity. Because you can't have the agency every Monday morning facing a judicial review. Because in fact, every day of the week, every day of the year, they would be in court, battling on the question of whether they have the right to do this and whether they have the right to do that. So there's a certain degree of cloaking. I'm using layman's language. The lawyers in the audience know what I'm talking about. A certain degree of immunity needs to be, an inoculation needs to be built into how the thing is structured. But what happens if after all of that, so you're trying to build a new agency to deal with a serious problem, what happens if after all of that you get the wrong people working in there? So you have a high threshold for the removal of the executives. They have to be convicted of bankruptcy, and they have to go insane, and a whole high, the list of 5 things or 6 things. But suppose they never do any of those things, but they just don't do their job. They're lazy. They're in bed. They didn't have friends when you appointed them, they get friends after, and so on. So this is something that we need to really grapple with, the question of how do we monitor these important agencies. It's a problem that we haven't got an answer to, but I'll be getting to some practical things here now. And I now want to get to this question we don't really want to, I'm going to say it's state capture. What is that? Is it real? I'm going to talk about it. I have 2 examples I'm going to give you. Between Trinidad and Tobago and Guyana, I'm not going thousands of miles away. Right here, we have state capture. Does it exist in our countries? Or is it something that happens somewhere else? You see? We'll come back to that. The 2 state capture examples I'll give. The first one concerns the deliberate attempt to dismantle our country's integrity framework with respect to our telecommunication sector. And the second one concerns a gentleman who is trying to make advances or smiling and dancing towards Guyana, Mr. Lawrence Dupree, and CL Financial. I will talk in some detail about that and say what I have to say. You will say what you want to say back to me. So we have an integrity commission that was established in law in the Integrity of Public Life Act of 2000. And financial disclosure, which parallels the Guyanese Act, is an important part of it, as Section 3, Part 3 of the Act. And then there's a code of conduct. And the code of conduct is contained at Part 4 of the Integrity in Private Life Act, in Public Life Act. And we could also talk about how the persons in public life are defined in our regulations. So the persons in public life are defined broadly. So you have ministers, and you have people who are county councillors, and you have the prime minister, and so on and so on. And there are 2 really interesting exceptions. Really interesting. The first exception, which I'll get into in a little bit just now, is that judges and magistrates are now exempt, which was never the intention of the Parliament, but that's what happened, and I'll get into that, because we're talking about state capture and wicked litigation. And the second exception, which was intended in the legislation, is that CEOs of state enterprises are not included in the Trinidad and Tobago Act. The other thing I want to say is that there's a practice, it's not contained anywhere in the regulations or the law, there's a practice in the Integrity Commission of Trinidad and Tobago that I want to warn Guyana against, because it's something that I think is entirely wrong, counterproductive, doesn't make any sense. But one of the things that they do, out of a sense of being gentlemanly, is that if you are a public official and there's a report against you as chairman of A, B, or C, and they intend to investigate you, they notify you. So this will seem comical, but it's true. They would actually write you and say, sir, you are chairman of ABC. We have received a report of XYZ, and we are starting an investigation into you. It's perfectly ridiculous, but true. It's Alice in Wonderland down there in Trinidad. And this is the gentlemanly code that applies to white-collar crime. Could you imagine somebody accused of rape or murder? There's a report in the police that this person or that person carried out a rape or murder, and the police would telephone them and say, listen, we're coming to investigate you because last night, it wouldn't happen. At least it ought not to happen. I shouldn't say it wouldn't happen. And the other thing is that the track record of the Integrity Commission is really very notable in how much it's failed. So millions of dollars go into it every year. They've crashed up against a lack of performance, and all of their efforts appear to exist in relation to the financial disclosure. So they want to know if you filled out the form, and if you gave these details, and did you file in time, and so on and so on. They have put no effort into the code of conduct. And quite frankly, as somebody who has made this a big part of my work, that is a wasteful use of resources. So my suggestion again, for people who are mindful of the Integrity Commission's role, and I know it's coming back on stream in Guyana, my suggestion is that the Integrity Commission's limited resources should be focused on the code of conduct and investigating reports that are received about the chairman of ABC without notifying them. Okay? And now I move to the Guyanese State Asset Recovery Agency, Brian. And I have a few comments about it. I'm not an attorney, and the room is full of attorneys, so I'm a little nervous, and I'm glad my back is to the wall, so I'm not that afraid. But the first thing I'll say is that there's a robust law to recover assets. And what is interesting about it, and I think commendable, is that it's not just a piece of law hanging in a vacuum, it actually establishes an agency. Because in Trinidad and Tobago, we have similar laws. We have Prevention of Corruption Act, 1999. We have Proceeds of Crime Act, 2000, and so on and so on. But no agency. So the same fraud squad and the same detective in the CID, they're now supposed to implement these successive layers upon layers of complex legislation. And it hasn't happened, obviously, because the corruption in Trinidad and Tobago grows by leaps and bounds, while more and more laws go by leaps and bounds. So it's very commendable that Guyana has put an agency in place. I want to talk about a few features of the legislation
that I think need
some thinking. So, for example, I think mortgages and guarantees, because one of the big things the agency focuses against is the recovery of property, meaning real estate. And one of the things we observed in Trinidad and Tobago with our property and construction related crime is the creation of convenient documentation to mask a situation. So mortgages and guarantees need to be particularly examined, as well as the linkages between people. So, for example, in the case in Trinidad and Tobago with the Piaco Airport, with Mr. Pandey and those sorts of people, some of the people who are listed to be prosecuted are from Maritime Insurance Company. And you might wonder, Why is an insurance company? People who don't know about the construction industry, you wonder why is an insurance company becoming part of a lawsuit about an airport? Now, the people from Grand Thornton might know, but what was done was that there were tender packages. Tenders were invited for various packages of work, and the fraudulent contractors would put a tender forward that was quotation marks competitive, and one of the documents you're supposed to include in a tender is a performance bond. And a performance bond is an insurance policy. And Maritime was issuing the performance bond. And they had what you might want to call a filial and a comfortable relationship with Maritime. So Maritime issuing these performance bonds for these hundreds of millions of dollars of contracts, and Maritime's balance sheet was in no way, shape or form able to carry that load. So you're just issuing bits of paper. You see it? That testify that you could support a construction project of 200 million and 150 million. You don't have the assets in the balance sheet for it. So therefore, from the SARA perspective, one has to be careful about convenient mortgages. Because if I was a corrupt official and I got hold of a property that was worth about 5 million US, and I knew that there was an agency called SARA that had just been sort of set up and were getting themselves organized, I wouldn't keep that property. I would talk to my man in the bank and get him to give me a mortgage. The bank where I have my family and my friends and my shareholders and so on, I get him to give me a mortgage. So when you come for the property, it's a mortgage property, I stop paying and you and the bank have to fight. I go on, because I've cashed my money out, okay? Same thing with guarantees. Guarantees have the same function as far as property is concerned in this financial arena. So I think that there needs to be some sort of, in your regulations or something, I know the act is passed, you all need to find a way to tangle with some of those issues. I mentioned yesterday that the immunities contained in section 104 of the SARA Act ought to be extended to cover litigation, because you could have a member of staff of a private organization or indeed a state organization who makes a whistleblowing report in breach of their employment obligations for confidentiality. And yes, you have provisions that they can't be dismissed and they can't be disciplined and so on, but you don't mention that they could be sued. So you need to put that in there as a bar to lawsuits, in my opinion. I really like section 53, subsection 2, because there's a 12-year rule in section 53 in terms of the length of time you can investigate. And section 53.2 is a sweet section. Lovely. Whoever did it. Lovely. Because 53.2 actually says that the time for the 12-year rule doesn't start running until the act of fraud is discovered. Yeah, very beautiful. And it reminds me, which I can talk about in question time, of the epic litigation in Trinidad and Tobago of the Attorney General versus the Board of E-Tech on a similar principle on our 4-year rule in our Liability Act, our Limitation Act. The double jeopardy rule, which is one of those common law and long time protections, is well recognized, but it's artfully dealt with, properly dealt with, because it's upheld the double jeopardy rule, except for the case of perjury. So that was also very well done. The annual report, I wasn't happy with those provisions. Those provisions are towards the end of the Act. And the annual report provisions contain what I consider to be a fatal phrase, where in fact you say the annual report is to be delivered as soon as possible. I winced. Then you need to set a date, because it may be you today, and tomorrow if it's another political persuasion, as soon as possible could be never, never. So put a date and put a penalty, but as soon as possible for me, very uncomfortable. Okay? Final point on the SARA Act, and indeed on the Procurement Act, is that I find the fines to be quite low. I don't think they're punitive. Okay, so you get I think a bank is a $10 million fine and so on and so on. And given the rate at which money is happening here, that's not, in my opinion, punitive. How much time have I got? 15? 15? Okay, right. So now what I want to do, that's my points on the SARA, and I'm happy to engage afterwards in any discussion or debate about it with colleagues. What I want to do now is move on to the two examples I promised about, what did we call it? State capture. That was it, state capture, right? Right. So the first thing is what I call wicked litigation. Wicked litigation. And I called it the twin track attack. And we had a situation in our country where the Integrity in Public Life Act and the Freedom of Information Act were passed in 1999 and 2000, respectively, by the Basdeo Pandey administration. The Basdeo Pandey administration was followed by another administration, which is the Patrick Manning administration, which Eric was part of that team at one time. And the Patrick Manning administration faced a conundrum. And the conundrum is this. It's a democratic country where all law-abiding people, we all talk about accountability, transparency, and good governance. But in fact, those laws made you very uncomfortable. How do you deal with it? And we saw what I have come to call a twin track attack. And I'm speaking here to those of you who would be running institutions, public institutions, important ones. Those of you who would be advisors or members of civil society, who need to be aware of what is happening and what can happen and what are the signs when a state is being captured or controlled by certain interests. And I'm going to itemize the case. So in May of 2009, you had left the cabinet by then. In May of 2009, the then Attorney General, which was Bridget Anisette George, put into Parliament a proposed amendment to our Integrity in Public Life Act 2000. And what the Honorable Attorney General, as she then was, proposed was that if you want to make a report to the Integrity Commission, you have to give full particulars, your name, your address, and everything about yourself. Could you imagine that in our country? That's a license for white-collar crime. So the rapist and the murderer and the carjacker and the bank robber, you have a telephone number in the newspaper, 800 tips. You call anonymously and give your information. But if you want to report on a minister or the chairman of ABC, you have to give your particulars. And of course, there was a ferocious battle in the Parliament over it. Because they tried it. This is why I call it a twin track attack. This is the first track. And they had to withdraw under cover of shame. So some of us wouldn't be quiet about it. So understand this. The very AG of a democratically elected government could bring that into Parliament and tender it as a proposal to change the law in the country. I tell you. Okay. Second example, TSTT. TSTT is the Telecommunication Services of Trinidad and Tobago. And to give a context, it is the largest non-energy company in Trinidad and Tobago. The largest non-energy company in terms of revenue, staff, and so on and so on. In terms of national transformation and development, its importance cannot be overstated. Because we are talking about the new world. Yesterday I spoke about the fact that information is now the most valuable commodity on the planet, more so than oil and gas, and the information is flowing on the information highway, and the information highway is built on a structure of ICT. And we in Trinidad and Tobago have the Telecommunication Services of Trinidad and Tobago. That is 49% owned by the state into an organ called National Enterprises Ltd. 18% of National Enterprises belongs to citizens like myself. 82% belongs to the state. I'm getting a bit mathematical, but that's how it is. And 51% of TSTT belongs to Cable and Wireless, the British multinational. Cable and Wireless have now sold their shares to Flow. Flow is flying under the flag now of Liberty Telecommunications, also multinational. And a big fight developed, and I see the lady from Grenada's Integrity Commission looking at me, a big fight developed in which, and we have to note these things, in which our Integrity Commission filed a case in court, and it's what the lawyers call an interpretation case. So having been charged by Parliament and given the duty to monitor a particular set of organizations, including state enterprises and public-private partnerships and statutory bodies. They filed a case in court to ask the court if that's what the legislature really meant. So now we start playing the fool with a big constitutional issue. Because it's a constitutional issue. We have the three limbs. We have the judiciary, we have the legislature, and we have the executive. The executive is now dancing with the judiciary to dilute the intended work of the legislature. That's what happened. Okay? It's very serious. Joining in the lawsuit, TSTT joins the lawsuit to say that since we have foreign shareholders, we don't want to be part of that act. And in 2007, because the case was filed in 2005, in 2007, the High Court found that TSTT is a public authority, which is the phrase that is used. And TSTT is liable to follow the Integrity in Public Life Act. And that ruling would delight you until you learn that the judge in question also ruled on something that I don't think anybody submitted on it, but that's how it goes in the learning profession sometimes. And she ruled that judges and magistrates no longer have to file. So judges and magistrates had an out. Okay? So the intention of TSTT and the Integrity Commission was to remove a certain amount of the work the legislature had given them and a certain amount of the oversight. The effect, they lost the High Court case, but the judges and magistrates found themselves exempted. Lawfully exempted. This is all lawful stuff. That doesn't make it correct in my opinion. We then went to the appeal court, and that case, it was finished, the hearings were finished in the middle of 2010. And it took the appeal court 3 years to write the ruling. 3 years. And that ruling is monstrous. It was delivered on the 27th of June 2013. And our appeal court in Trinidad and Tobago found that TSTT is not a state enterprise for the purposes of the Integrity Act. Running alongside that, because we need to be really careful and pay attention, running alongside that, there was a Freedom of Information case. So a case was filed against TSTT that in fact they had received a letter from the Integrity Commission. Again, incredible. The Integrity Commission wrote a letter to the directors of TSTT telling them as long as this litigation is going on, you don't have to fill the declarations out. So you have a public institution writing a letter, headed letter in 2005 to an organ and to persons in public life who ought to report to it, telling them, don't bother to report, let's wait for the end of the litigation. So someone sued, that person went on to become AG. Someone sued to get that letter because the letter was from the Integrity Commission to TSTT. And the case went on and on and on and on and on. And of course, by the time it got to 28th of October of 2013, a different political change had taken place. So the chap who filed the case was now the AG. As we say in Trinidad and Tobago, everything is everything. And they agreed to compromise the case. That's the word lawyers use when they have settled the case. They agreed to compromise the case. And they struck out the judgment of the lower court, which found that TSTT was supposed to perform the Freedom of Information Act. And in fact, what we have now is a situation where TSTT has lawfully been excluded from the Integrity Act. Its case on the Freedom of Information Act has been artfully thwarted. And the importance of it coming back to first principles is that at this precise juncture, with the decline in our oil and gas fortunes and the rise of the information era, TSTT is in fact the key company in terms of our public institutions, in terms of where we take things in our country. But so deep is the scheme in terms of state capture, so deep is the scheme that this litigation started since 2005. Understand me very well, colleagues and comrades. This litigation started since 2005. To get to the point in 2017 where you can't ask TSTT anything. Because the appeal court said this and the High Court said that. So colleagues and comrades who are important and you are in charge of important institutions for this generation and the next, be mindful of it. Is that? No, that's not for me. I want to finish off quickly. I know I have 4 minutes. I want to finish off quickly. So that was my first example about state capture. I want to finish off quickly by talking about Mr. Lawrence Dupree. I know Mr. Lawrence Dupree and his cohort have been making overtures to the Guyanese government. They want to come back here, they want to build housing, they will pay back some, and when they get a chance, they'll pay back some more, and all of that stuff. As far as I'm concerned, the CL financial collapse and bailout, and particularly the bailout, is an epic financial crime. It's the biggest financial crime and economic collapse that's taken place in the region for 100 years. The amount of money estimated by our Minister of Finance on the 19th of May this year, when he gave his mid-year budget review, the amount of money estimated to be spent on that is 27.7 billion Trinidad and Tobago dollars. A country this small, and we could find 4-point-something billion US dollars to pay off this man's debts. We don't have enough soap in the public hospital. We don't have enough money to have toilet paper in the public hospital. But we have enough money. You understand me? That's the size of what it is we're dealing with. And the Trinidad and Tobago administrations, successive administrations, have been culpable. I'm going to race through this point. Have been culpable in dismantling our country's integrity framework where this situation is concerned. So Mr. Dupree and Mr. Montai, for all of their financial sins and their wrongdoing, when they were in charge, every year CL Financial had annual audited accounts. The instant the Trinidad and Tobago government took charge, annual audited accounts stopped. Like the magician say, shwa. Okay? The last time they had annual audited accounts was the 31st of December 2007. 10 years. Okay? The Integrity in Public Life Act ought to cover these directors of CL Financial because it's a company that is funded by the state and controlled by the state by means of the shareholders agreement. The majority of the directors are appointed on the board from the state. The Integrity in Public Life Act has not been enforced. I have accused the Integrity Commission of the phrase is willful blindness. They won't do it. The Freedom of Information Act, I took the government to court and won the case on the 22nd of July 2015 to get the details of what money they've paid out, who have they paid it to, what did they tell Parliament, the names of the people who got the money, the audited accounts. Right now, the new administration of Dr. Rowley has engaged me in the appeal court. They don't want to tell. As we say in Trinidad and Tobago, they can't tell because it's a cartel. You understand? And lastly, now I'm very serious. This is a very serious matter. State capture is not a theoretical concept. It's not a theoretical framework. It's not something that happens somewhere else. It's probably happening to you sometimes and you don't even know it's happening to you. And in the first case of TSTT, I was not very alert. In this case, I'm on it. And the final point I want to make, wrapping up here, is judicial review is a very important element that we need to root in our law. I understand there's a Judicial Review Act in Guyana. I also understand it has not yet been, I think proclaimed is the phrase, not been proclaimed as yet, although there are provisions of judicial review in the procurement law and in the SARA. But I don't know that the actual act has been rooted yet. I would leave it there for now. I hope I've made the case that these are things that we need to be alert about. Okay? I started off with the gory example in the Grenfell Towers, and it's a serious thing. So the cost-based approach is no joke.